Hi, good evening to all of you. Before we could start for the day, all right, final series of the third day, can I confirm whether you can hear me? Thanks, Samuel. So we are off for the final day, as I said just now, and it's going to be a very important day, I believe so, okay, for all of you, as we are firstly, because we have the final 3 hours, we are going to focus on the compulsory question first. All right, will take about 2 hours or so. Then if we can successfully complete the compulsory question, then the remaining time we will look into the non-popular area. At least we will have a flare of time to cover the compulsory question. And through speed, I have actually sent the attachments of the actual article, right, on the rule in Wilkinson and Downton. And at the same time, okay, I have actually done a summary of it. Okay, so we will be looking into that first, and then we will look into the Q&A, question and answer. But before that, I sent you the questions only for you to reflect back. Okay, the type of questions that you may experience during examinations on this particular topic itself. All right. And after that, I will also share with you the suggested guideline or rather suggested answer that you can have in order for you to get yourself ready when you are being questioned. And if the questions are similar, then I hope that, okay, you will know what to do already, okay, for the examination purposes. So once that is done, then with the remainder time, we will look into liability for public bodies. Basically is about negligence only, but especially concentrating on duty of care on the part of action and omission for public bodies, a specific duty situation as to whether a duty of care can be owed by the public body towards any form of injuries or losses sustained by the victims of tort. So that which I have a few questions lined up for you to take note how different the questions are, and so that you can keep it as the reading material to prepare for the examination. All right. So having said that, let's run through the material first. Okay, let's run through firstly the original document just to ensure that you receive the document that I have actually sent to you, right? Titled as Modernizing the Tort of Wilkinson and Downton. Tort of Wilkinson and Downton. Okay, in the event that the internet is not smooth, kindly alert me. But I think at the moment it's fine. By Rachel Mulheron. Okay, this particular journal was done last year, okay, based on the case that has been cited, all right, in 1897. Very old case, which happened in a pub in London. So based on this, the author highlighted the rule in itself and decided to see whether if this rule can be revised, and then it gives life. We make a life, okay, or rather you make the rule to be more lively, okay, in today's perspective, okay, rather than making the rule to be so redundant and very rarely being used by the court of law. So instead of, okay, eliminating such a rule or making the rule redundant or abandoned altogether, why not we modify the rule and to see whether it serves a very good purpose, okay, in this modern world. So the current perspective of the old rule and also suggested modification then and now, and then a bit of a photograph of that particular pub in itself, and some of the cases being cited, such as Wainwright, Victoria Railway against Coltas, and then of course PHA also was there, okay, highlighted by the author. Moving further, okay, the reformation that suggested by the author on the threshold harm in itself, okay. Okay, and further on page 6, okay, there are a few perspectives that the author suggested to be looked into. One is the medical perspective, and the other one, if I'm not mistaken, the legal perspective. Okay, so one is medical perspective, and the other one, the legal perspective. Okay, I hope that this is a document that I sent to you, because this document has areas where I've actually highlighted, okay, together with some notes that I have there, right? For you to observe maybe the meaning or some abbreviation to those information, or what we call the title or terms, okay? Then the Reformation divided into a few segments. One is the Reformation of the conduct elements suggested by the author, right? What is the difference between conduct versus statement? Further, the concept of directed statements, false statements, and intermediate acts. Then excusing defendant's conduct, part of it, where we talk about the intent part, okay? How the author was reflecting the issue of intentional tort here, right? The spectrum of intent, okay, there are various spectrum that has been highlighted, and which spectrum this particular tort can be used, okay, to make the law more useful, okay? The spectrum of intent. And moving forward is the suggestion for the revise, okay, what could have been the suggestion? And the consequent part of it, causation, of course, okay, the author also was talking about causation, relevant causation element that we can use together with remoteness of damage. And then the author also, okay, suggested a new defense to this particular tort. Okay, a new defense for this particular tort. And finally, it went into a conclusion, and good enough, okay, the author also, okay, took some initiative to put a summary, okay, of the proposed reform, so that we will be able to see the overall picture as to where the focus made by the author in itself. So basically, this is what Rachel Mulheron highlighted, okay, in her article on the reformation of the rule in Wilkinson and Downton. So some of the most what we call these familiar cases and common cases that you can see cited by the authors, such as Janvier and Sweeney. You can see Khorasanjian and Bush here. Sorry, I think I've clicked. I shouldn't have clicked it. Okay, right. And here you can see further on those pages like Wainwright and Home Office. Okay, A Hall, Rhodes and OPO, W Essex. This is a psychiatric illness case. Okay, right. And other than that, Julian White, I believe you all know, also psychiatric illness. Okay, McLaughlin O'Brien. All these are cases which have been referred by the author. Okay, the common cases. Author also did highlight Hunter and Canary Wharf. Okay, for some reason or another. Okay, and then that's it, I would say. Yeah, these are the cases. Other than that, do I see anything that is familiar throughout your studies? Other than, no, the frequently referred case will be definitely Rhodes and OPO, Rhodes and OPO 2015. Okay. No, no. I'm still browsing through to see whether any other common cases that you have gone through which was referred by the author. No, not really. Other than that, those cases could have been very uncommon, or could have been uncommon to you. Right. So here we are going to sit down and analyze and see, okay, on how are we going to observe this particular tort. And eventually when we go into Q&A, I think this is the first time we are doing a compulsory article in level 5. Level 4, yes, you have done case notes. So there are certain things that I need to advise you on how you can actually answer those questions and what can be the do and don'ts. There are certain things that you may think that you would like to, deliberate or, explain in the examination, but which may not be necessary. So a few things at that point of time, I expect your active participation on asking question. So students will need to know the scope of answering this. That is important because sometimes, okay, students may ask, sir, what about the footnote cases? Do I need to go through in detail or not? That's an example, right? Because we don't know, okay, whether, okay, you can state anything from outside this particular article. Is it possible, or what is the extent if it is possible? All these things are later part, okay, after going through the whole structure of the rule in itself. Now, first of all, the first step is we need to look into the rule based on the facts of the case and identify the rule in itself in, uh, in its dissection. I would say, we try to segmentalize the statement of principle, or rather the rule in itself in Wilkinson and Downton. Then from there only we will know. And by by a common understanding, the rule in Wilkinson Downton orthodoxically, okay, right? The moment, okay, this particular rule was set in 1897. It was parked, I would say. It was parked under intentional tort, that is the trespass to the person. So the question now is it still under the same particular aspect of tort, i.e. trespass to the person? Even if it is so, is there any form of overlap that you can observe, okay, as to this particular tort together with other torts that we do have, especially negligence? So these are some of the things that I would like to, expose you to know first before we zoom into the talk in itself. Right? Many of you would have gone through this talk, I believe so, during your lecture, but just for a reminder purposes, I'm doing so, right, on this talk. Let's look into the summary that I have actually sent through speed. The summary part of it is already there, right? When I send the document, let me extract the summary of the article from the rule in Wilkinson and Downton. I will share screen now. Okay. So in terms of summary, the first paragraph, or rather we call it the abstract, okay, it's not really a summary, it's just a copy and paste of that particular facts in itself. So look into the facts itself. A practical joke in Albion Pub in 1896. A practical joke. Sometimes we call it to be a prank in today's context. Many people like to do prank, am I right or not? So everyone will be thinking, prank, is it okay to do prank? Let's ask ourselves, what if due to a prank that we have made, somebody is suffering from a personal injury? Okay, are we going to be responsible? So prank seems to be a very common practice in the younger generation today, but it can be serious. Okay, we don't say no, it can be serious if, okay, somebody is harmed as a result of the prank that you have actually done or committed. So a practical joke in the Albion Pub in 1896 in East London spawned a cause of action. The rule in Wilkinson and Downton, which persists to this day. However, the thought has suffered from limited utility since Justice Wright's famous judgment. So it is argued in this article that the time has come to reform and to modernize the tort so as to compensate the claimant who has been the subject of a defendant's statement made intentionally to cause that claimant serious emotional distress. To cause the claimant serious emotional distress. So reforming the tort will fill a gap in tort law. Fill a gap. There is a lacuna in the tort law. Tort is a very unique subject, okay, or rather area of law, substantive law, because tort covers every other loopholes existed in the law of the state, whatever law you call it to be, overall perspective of the substantive laws. Whenever there is a gap, okay, we have a solution. We have a savior, that is tort law. But even within that, if we have a gap, what can we do? We need to fill in the gap. If not, okay, there is a lacuna within the, all right, tort which is supposed to cover the gap in other laws. Basically, this is what we need to understand about tort law in itself, because it's a law of wrong. It's a law pertaining to fault of one person, okay? Many people, okay, can be at fault, even in contract, in crime, in what we call intellectual property aspects, in, land law. People can be wrong. So tort law, if at all is not governed under those substantive law, tort law should be there to protect, okay? So reforming the tort will fill a gap in tort law by enabling the protection of claimants' personal integrity in circumstances of intentional wrongdoing, which other torts do not currently facilitate. It would also refashion the tort for modern societal conditions, in which one of threats, suggestions, requests, and statements, whether it's written, image-based, and pictorial, and directed towards C via social media platforms, electronic communication, TikTok, and other media, can do substantial mental harm. So the reason, the invocation of the modernization suggested by the author was particularly due to, right, the modernization of the technologies, and that can cause harm to people. So if you reflect to many other torts which cannot cover this, yes, of course, privacy law, it covers privacy issue, but it doesn't cover this kind of harm suffered by the people due to this kind of channels, this kind of media. So are we not? Why we not? Okay, create a tort, but no point creating a tort, but rather modernizing the tort would be a better option according to the author. Okay, so having said that, from the abstract that the author has actually prepared, right, she has actually gone into the tort in itself to explore, to see what can we do to modernize it. Now, as part of introduction, the summary of the introduction. The introduction was there in the article. This is a summary of the introduction. This article advocates for the reform of the tort of Wilkinson and Downton, a principle established in 1897, right, which has a limited application and success. Currently, all right, this tort, which is called the current Wilkinson tort. So whenever the phrase used current Wilkinson tort, it's a current tort, not a revised version suggested. Addresses cases where defendants' statements and conduct, okay, intentionally cause claimant physical injury. Okay, I would like to highlight it differently so they can see, okay, from the current tort itself, or emotional distress. Okay, physical injury or emotional distress, right, leading to a recognized psychiatric injury, So the proposed reform, proposed means revised, Wilkinson tort suggests a broader application. It will cover cases where the defendant's statement intentionally inflict physical injury, okay, or serious emotional distress. on C. So that is what, okay, the modification generally suggested, a broader application, I would say, broader application. So the need for the reform is highlighted by the torts as past a successful application. In over 120 years, only 4 cases in England, which means, right, only 4 cases were decided, okay, in accordance with the old tort. Okay, old Wilkinson and Downton. That shows that, okay, the use of Wilkinson and Downton's was very, very rare. So, right, it's almost none, in the 120 years. Whereas if you look into other torts like negligence, every now and then, every day, you can see negligence cases. So something needs to be done for the tort. So this lack of effectiveness and the evolving societal condition. You see, nowadays, the examiners or rather the authors or academicians always like to observe this particular concept called evolving societal condition. Things are changing. Law needs to evolve accordingly. People are changing. Society is changing. So our law needs to, all right, forerun to capture, all right, the kind of a society that we are living in, the kind of a problems that we are facing, right? Especially regarding the impact, okay, due to the impact of social media and electronic communication. That's where the focus is. So call for a modernized approach. Notably, 2 of the 4 successful cases in the last decade involve sexual misconduct by educators, indicating the tort's potential relevance in context of vulnerability and power imbalance. So the article proposes examining and justifying changes to the tort, focusing on the aspects like the threshold of harm. That's what we are looking at. Conduct part of it, intent part of it, consequences part of it, including causation and removal. So it also considers possible defenses, okay, and concludes with a discussion on the potential benefits of those reforms. Despite its global influence, the article specifically addresses the tort's application and needed changes within the English legal context, acknowledging its current limitation and the opportunity to fill a legal gap with a more applicable modernized version. Yeah. So that's basically the overall observation, okay, by way of introduction made by our author, Rachel Mulheron. Okay. So then and now, this excerpt discusses the historical concept of the proposed reform of the current Wilkinson tort originating from 1897. The incident led to this tort occurred in 1896 in London, where Mr. Downton falsely informed Mrs. Wilkinson that her husband had been seriously injured. So there was a statement made, okay, by Mr. Downton. This joke caused Mrs. Wilkinson significant psychiatric injury, right? Of course, psychiatric injury was not a tort that can be easily recognized by the judges, okay, unless you are a primary victim. But even so, right, in 1897, okay, it was like, way back, okay, I would say about 11 or 12 years before, no, not 12 years, I think 14 years, 1897, 1900, 1901. Yeah, Dooley and White. It was 1901. So say about 14 years before. So the question is, can Mrs. Wilkinson claim for the psychiatric illness or not? Because the very first case that allowed for the claim for psychiatric illness was Dooley and White in 1901 or 1901. Yeah. So this was a very unique situation. That's why the rule was developed. Because at that point of time, psychiatric injury was not, okay, a harm that can be recognized but in the court of law. So leading to a landmark legal decision by Justice Wright. So it's not about the physical act that caused psychiatric injury, but it is a statement, right? So as far as we are concerned, surprisingly, as we know, when we have done psychiatric injury, we said that we came to know that the very case where the court recognized psychiatric injury was Dooley and White. Yes, that is true. under negligence. But the very case where the courts allowed a claim for psychiatric injury in the history of English law, not even Julian White, is actually Mrs. Wilkinson when she suffered that. But it was not dealt under negligence because this is a unique facts. This is a facts that did not fall within, right, negligence, because Mr. Downton was not negligent. Mr. Downton intentionally caused this particular, right, effect to Mrs. Wilkinson. But if the what we call the effect, the consequence might not have been intended, but the action was intentional. The action was not negligent. The statement made was not negligent, right? It was intentional. So that led to Justice Wright created a new cause of action for inflicted psychiatric injury. Are we clear? So the current tort, which is the old one, we are talking about, not a revised tort. The current tort has remained largely unsuccessful and limited in its application, leading to suggestions for its reforms. Revised Wilkinson tort. The proposed revision aims to address gap in the law by covering serious one-off incidents and verbal threats intended to cause distress. Intended to cause distress. Might not be psychiatric injury, but intended to cause distress, which are not adequately covered by other torts or criminal law. So the revision is particularly relevant in the context of modern communication technologies like social media and texting, which can cause serious emotional distress. So the article suggests that while other torts like defamation, battery, and negligence address some related issues, they do not fully cover the scope of harms the revised Wilkinson tort is designed, all right, to address. The criminal law also does not fill this gap, as it is often does not provide compensatory redress for the types of harm contemplated by the revised Wilkinson tort. So the need for reform is underscored by the changing nature of communication and the increased ability to inflict emotional distress through electronic means. The article suggests that with appropriate adjustment, the Wilkinson tort could be more effective in the modern era, particularly in handling cases involving emotional distress caused by intentional statements and threats. So the following section of the article are set to explore how each element of the current Wilkinson tort could be amended under this reform proposal, focusing on serious emotional distress and aligning more closely with trespass and negligence. Okay, trespass and negligence. That's where it's trying to fill in the gap or cover the gap or trying to align with trespass and negligence. So in short, okay, a bit of a brief when we talk about, hopefully it's the whiteboard is working, yeah, right, just a minute. Okay, so when we are looking at negligence, see, there is an act. There is an act and there is a consequence, or rather we call the damage suffered. We have an act and we have a damage suffered. So when we are referring to the act, okay, we realize that this is due to carelessness, right? Carelessness. And the damage that the person can suffer, right, can be divided into, right, 4 different parts. One is personal injury. Number 2 is property damage. Okay. Number 3 would be psychiatric injury. And the final one is pure economic loss. Whereas when we talk about trespass to the person, what we learn is, okay, the tort is intentional. So the act or omission, even in negligence, so we can talk about act or omission. Okay, and this act or omission is not due to carelessness, but rather is intentional, where it may cause personal injury, okay, or liberty at stake. So trespass to the person was a tort where you don't see when a person suffering from psychiatric injury that needs to be claimable, right? Because trespass to the person generally deals with people who are suffering from personal injury or even mere touching, actionable per se already, or assault, even no touching also. There can be a liability due to the act or omission, all right? So now, when a person is intentionally, there is an intention by using a statement causing psychiatric injury, we would say there is a gap because intention not covered by negligence, psychiatric injury is not covered by, right, trespass to the person. So there is a gap there. So when there is a gap there, the rule in Wilkinson and Downton can, okay, fix it up. But it's not good enough. That's what the author was trying to highlight. Okay, and plus, okay, if we would like to highlight it based on criminal law, then it's not available when you want to claim for compensation. So tort law must provide for some solution in this respect. Under criminal law, yes, okay, we can talk about the state is taking an action against the defendant if he's found guilty, but not under tort law because there's no tort that can cover to that extent. Yeah. So having said that, going back to your material, we will be looking into the reformation part of it, the threshold of harm. Firstly, we look into the threshold of harm. So whereas this section addresses the need to reform the threshold for harm in the revised Wilkinson tort. The current Wilkinson tort established in the case of Wilkinson and Downton requires proof of physical or psychiatric harm. Proof of physical or psychiatric harm, which means physical harm, personal injury, in other words, and or psychiatric harm. Psychiatric harm is a kind of a harm that is not easily recognizable. Medical evidence is required to be shown, right, before even the courts, agree for the case to go on. That means this is a precondition before a person can forward himself to further, okay, discussion or further what we call this establishment of other areas of other requirements of the tort itself, the negligence itself. So caused by the defendant's action. So historically, this tort primarily addressed indirect and consequential bodily injury resulting from mental harm. So, when this particular harm only acceptable by a statement, in 120 years, there were only 4 cases. This is what author is trying to say. So something must be done. So the author said that the concern that we are having now is the harm in itself, the mental harm, emotional part of it, the psychiatric part of it, okay, where the reform proposes a significant shift. We need to change it. And under the revised tort, the requirement would be changed to serious emotional distress rather than recognized psychiatric injury. So we need to change it to serious emotional distress. Then you can see wide cluster or more people will be able to take action against the defendant who had intentionally, not negligently. You see, there's a distinction. Under negligence, to claim for psychiatric injury, to claim for emotional distress is unlikely, such as more a mere depression, you know, right? Some kind of a mental disorder. It's not, unless you can prove that it is a recognizable psychiatric injury, because the other person was negligent. So you can't be blaming the defendant for every single type of harm that the claimant is suffering, because he's merely negligent. He was not intending to harm you. Whereas here, when someone intending to harm, then why should you make the threshold of harm so difficult? We must make the threshold of harm lower. That include emotional distress. That's good enough already. If not, it's very difficult for you to prove, because many people will suffer serious emotional distress, but not psychiatric harm. Right? So this change acknowledges that emotional distress can be significant even if it does not meet the strict criteria for recognized psychiatric condition, such as clinical depression or post-traumatic stress disorder, PTSD. Okay? So the idea is supported by academic, legal, and medical perspectives, suggesting a need to a broaden scope of compensable harm. Right? If you would have had the opportunity to read many textbook writers in their commentary, yeah, you can see the difficulties that they are seeing in the tort in itself when the requirement of psychiatric injury is required, right? So that's a suggestion, okay, indirectly to criticism being made, but suggestion was proposed, but not as a full-fledged, okay, suggestion like what Rachel Mulheron tried to say, okay? Judicial opinions also indicated support for this reform. Notably, okay, if you want to cite, we have Lord Hoffman. All right, suggested that intentional tort should allow compensation for distress and inconvenience. Some of you have been asking, okay, the other day, one of you all asked me, sir, protection of harassment, yeah, can we claim for that or not? Okay, on the aspect where someone is, threatening B, right? I said there must be repetition. Yeah, you are suffering from some form of a fear, am I right or not? So it is protected under what do you call Protection from Harassment Act. Okay, but there is a requirement under PHA that you need to fulfill, right? There's a requirement. If you don't fulfill that requirement, then it should fall under a category that we need to create. That is the rule in Wilkinson and Downton. Okay, so which are typically excluded in negligence, right? Distress and inconvenience typically excluded in negligence cases due to different policy consideration. So this view is shared by other judges who recognize the necessity of addressing significant distress caused by a defendant's actions, even if it falls short of a recognized psychiatric injury. So this reform aims to align the tort more closely with both medical understanding, right, and legal principles, recognizing the impact of serious emotional distress and offering a more appropriate legal remedy. So the proposed change would mark departure from the traditional requirement of a recognized psychiatric injury, acknowledging the broader spectrum of mental harm and that can result from intentional action. So let's look into them. One is medical perspective. So this section addresses the medical perspective on distinguishing between emotional distress and recognized psychiatric injury. It highlights the complexities in differentiating these conditions, challenging the clear-cut distinction commonly made. Even under psychiatric injury, there were a lot of complications that you could see, because medical technology cannot be said to be too advanced, and more new type of psychiatric injury being discovered, and it has been regulated, through the updates given by the particular department, or rather association we call British Medical Association, right? The BMA notes that there is no definitive point where grief or distress become a psychiatric illness, right? The view is supported by legal cases like Dickey and Flaxcorn, Glen Rhodes Limited, where the court acknowledged the similarity between anxiety and psychiatric harm. psychiatric harm, questioning the rationale for treating them distinctly under common law. So the medical profession in itself, okay, could not have very exhaustive list about it because it's a very, very thin line between one level to another level, okay, and right until the level of what we call insanity, okay. Right, so historically, anxiety and depression were seen as different manifestation of a single affective disorder. However, advancement of psychopharmacology in the mid-20th century led to these conditions being categorized separately, particularly with the development of DSM-3, okay? Right, this separation has been criticized for its lack of realism. Then it has been updated, okay, later, all right, to DSM-5, moved away from strict categorization, acknowledging a continuum in psychiatric conditions rather than discrete unitary phenomena. So a continuum in psychiatric conditions. So it can be a situation where psychiatric harm can be suffered, but it could have been initiated with a normal distress. So that needs to be understood and accepted by the medical profession. Earlier, it was not like, it must be immediate and it must be endorsed as psychiatric harm immediately, right? Not over a period kind of end harm that we are looking at. So this shift suggests that the legal insistence on a clear boundary between emotional distress and psychiatric injury is medically outdated and unrealistic. So the author suggested that the features of generalized anxiety disorder as categorized in DSM-5 could indicate the type of serious emotional distress relevant for the revised Wilkinson Tort. So that's the first suggestion. Put another category for the purpose of, okay, Wilkinson and Downton, all right, that Wilkinson Tort, I call, where there can be a serious emotional distress. So what is meant by serious emotional distress? Let's, okay, identify, right? Not necessarily a psychiatric illness. So this includes distress that significantly interferes with the psychological functioning, psychosocial functioning, is pervasive and long-lasting, impairs social and occupational functioning, and is accompanied by physical symptoms. The assessment would consider the extent of impairment in cognitive functions, daily activities, the need for medical care, and the impact on social or employment settings, right? I wouldn't know, maybe some of you are involved in the medical fraternity, right? I do not know exact profession of yours, so probably you may have some better understanding of this kind of mental diseases that we call, so-called the mental diseases, from the normal distress to the real grave illness that people are facing. All right. Okay, having said that, that is one summary. Of course, the article is longer. This is the summary part of it. Second one is the legal perspective, where this section presents the legal rationale for proposing a lower threshold of harm under the revised Wilkinson Tort, highlighting 4 key points. One is intention part of it. So the revised Wilkinson involved intentional harm, where the defendant's actions are deliberate, not careless or accidental. This intentional nature justifies a lower threshold for harm compared to negligence cases. The legal principle is that the intentional harm should be treated more stringently, as emphasized by Lord Hoffman and the Supreme Court in relevant cases, that in the article, I would say. Number 2, comparison with other intentional tort. Many intentional or malicious torts, such as battery, assault, false imprisonment, and malicious prosecution, already recognize emotional distress as a form of harm, such as assault. Person is apprehending battery, he can either be in a very normal position or he can even be in a very distressed condition. Why not? So when other intentional torts already recognizing that and claimable, why are we making Wilkinson and Downton so stringent that you must suffer psychiatric injury? It should be a normal distress. That's good. Yeah. Or serious emotional distress to the very least, right? So this contrasts with the current tort, which seems misaligned with these torts due to its higher threshold for harm. So you must go in line with other intentional tort. Statutory torts and emotional distress, such as Protection from Harassment Act, various other torts. So we can talk about like those under the protection from harassment, recognized claim for anxiety or distress without accompanying physical injury. So this suggests there is a legal precedent for accepting a lower threshold. So we should also, this is justification, I would say, why we need to lower, right, the threshold of harm over here, right? And consistency in terms of the legal elements. There's a need for consistency between between the intent required under the tort and the level of harm recognized. If the intent is to cause significant distress, it's challenging to reconcile this with a requirement for a recognized psychiatric injury. Therefore, aligning the threshold of harm with the intent element makes doctrinal sense. It's coherent, in other words, right? It's coherent. All these torts are intentional, and the harm suffered can be as low as distress. Good enough, right? You can sue. So the article emphasizes not every minor or transient emotional distress, of course, not too mild, lead to compensation. There is a de minimis principle here, a de minimis threshold, right, is maintained in English tort law to ensure that only serious cases of emotional distress, not necessarily psychiatric injury, but it must be a serious emotional distress. This approach aligns the revised Wilkinson tort with existing legal framework and recognizes the severity and impact of intentional emotional harm. Right? So this is generally the legal perspective which comes to our understanding of what kind of conduct that we are going to recognize. Okay, we call it as a reforming the conduct element. What kind of conduct that we can actually accept, right? Should we broaden it for any type of conduct, whether it's an act or omission or it's a statement, or should we confine it? Because the purpose that the author was trying to highlight here is it's due to the modernization of technology. So maybe there is some qualification to be made on the aspect of what we call the actus reus in the criminal sense. But here we are looking at tort law. So this section discusses the evolution of potential reform for the current tort, focusing on the distinction between conduct and statement as triggers for the tort. Current Wilkinson tort has expanded to include 3 types of conduct that can trigger the tort. This is the current one, the old one. Right. Conveying false information to C. Conveying false information to C, where C believes it to be true. Verbally threatening C in a way that causes harm without indicating an immediate intention to commit battery. And third, committing an intentional act against C, right, to cause harm, which can range from various actions like deliberately letting a guard dog loose to more severe acts like hostage taking. All right. However, there has been a judicial concern about this broad application. In this case, in the case of Rhodes, Lord Newberger suggested, right, limiting the tort to distressing statements. Limiting the tort. Lord Newberger, all right, suggested limiting the tort to distressing statement. A viewpoint supported by other legal opinions. Consequently, the author of the article argues that the revised tort should focus specifically on defendants' a statement intended to inflict emotional distress. This is what the author is suggesting, rather than opening it up to other kind of conducts, more of a statement, right? So this includes wide interpretation of statements such as false information, threats, demands, warning, images, videos, and other forms of communication. So that's what the author said. So this proposed focus on statement raises the issue of how to handle one-off incidents of conduct by defendant that don't involve statements directed at C. The article suggests the most cases under the current tort involving defendant's conduct also included statements and thus would be covered under device tort. For rare cases where conduct occurs without statements, other remedies are available. right? Such as assault battery. So we don't need to go under Wilkinson and Downton. Let's have Wilkinson and Downton focus on statements alone, because there are other torts to cover other types of actions. Yeah. Ultimately, the article proposes the revised tort should not cover one-off incident of conduct without accompanying statement, as other legal avenues exist for this situation. This approach would realign the tort more closely with its original focus on distressing statements in line with some judicial preferences, right? So, director's statement, next part. So the statement must be, since we are talking about statements, let's go into the details of the statement, right? So this section discusses how the revised tort should address the issue of directed statement, focusing on two main questions. One, whether the defendant's statement needs to be addressed directly in person, and whether statement needs to be directed to C individually or as part of a group. So how are we going to analyze this? It can be one person, it can be a group, or it can be a huge class, or it can be indeterminate. We do not know. Where are we going to go for? So author said, firstly, we look into direct and in-person statement. Right? So the article explores the scenario of distant victims, where defendant's statement directed towards C, but conveyed through a third party. So this situation is increasingly relevant in the context of modern communication, social media, where statements can be passed on to C through various intermediaries. Author argues that such indirect communication should not be excluded, which means should be included under the revised tort, considering the reality of how information is disseminated today. However, the role of TP, or rather the role of a third party, in communicating the information of threat would be a factor in assessing causation. That part, that is a different segment altogether. Two, individual or group targeting. So there is a judicial divide on whether the defendant's statement must be directed to C as an individual or a part of a group. So the article cites cases where this issue has been considered, such as in Breslin against McKenna, and also the case of Rhodes, showing different judicial approaches. So author suggests now, for the revised tort, defendant's statement should be directed to C either individually or as a member of a small identifiable group. That's good enough already. Don't go beyond that. And this excludes statements directed at large groups or public at large, providing a necessary limitation. If not, it becomes a floodgate of litigation already. Yeah, in sense, like you go to a classroom and you direct this statement that is different compared to social media in the public, then you can't be blaming this person, because anyone can get affected, but that doesn't mean that you are directing. It's not intentional anymore to that extent. Okay, so the rationale is that narrowly directed statements are more aligned with the tort's intention and modern communication realities. So in summary, the article proposes that the revised tort should include statement directed towards the individual or a small identifiable group, whether communicated directly or through intermediaries, aligning the tort with current societal communication methods and providing a clear framework for applicability. So that's the second part, right? Instead of act, it's conduct. It's more of a statement. This section, the false statement section, an intermediate part. So the false statement, the statement itself, the content of the statement itself now. So this section discusses the relationship between the false statements, intermediate acts, and the causation of injury in the context of revised tort. The key points here highlighted by the author, okay, are direct causation by statements, which means the primary requirement under revised Wilkinson tort is that the statement itself must be directly cause injury or serious emotional distress. Example include instances where false information or threats directly led to emotional distress. Example, direct example, Mr. Downton, okay, and Mr. Wong. That's another case, yeah, highlighted by the author. So intermediate acts following false statements. There are situations where false statements by the defendant does not directly cause emotional distress. These are situations where false statement by the defendant does not directly cause emotional distress, but creates a scenario where an intermediate act, typically by third party, leads to the distress. This is another form. This can be seen as an omission where defendant's statement leads to a situation that allows TP to cause harm to C. I did not cause direct harm, but that has led third party to cause the harm to C due to my statement intentionally made. Right? It's something like trespass to person, battery. I throw the squib, the case of Scott and Shepherd, throw the squib, then pass on, okay? And the final person got injured. Yeah, intentional, but it was passed on to others and the other person suffered harm. But this one is a statement. When I make a statement to you and you interpreted it, and because of that statement, you harm another. So it is also possible under the rule in Wilkinson and Downton, according to the author. Thirdly, exclusion of omission scenarios. The article suggests that the revised tort should not apply to cases where the emotional distress is caused by an intermediary act following an omission or a false statement by the defendant. Okay, should not apply in this kind of situation. An example is W against Essex County Council, where this one is a foster parents, okay, suffered harm due to the action of the foster child, but not directly because of the misinformation given by the council, but the council gave a wrong information. What do you call this? The wrong information, not because of misinformation by the council, but because, right, the third party action, okay, which is the action that has been conducted by third party resulted in emotional distress, where the child, the boy that they have actually fostered, right? I don't know whether you can remember this case where the mother, this mother, they had, the father and mother, right? They had these two children, girl, right? And then they wanted to adopt a boy, okay? So they went to the county council and looked for suitable boy, okay, for them to adopt, right? And the county council suggested, okay, a particular boy, 15-year-old, and say that this boy is very good in terms of character and all this thing. So in reliance of that, okay, they adopted the child. And over the period of in a year, when the parents were not in the house, the boy sexually abused the girls. So when the mother came to know about it, she suffered psychiatric illness. Right, the court ruled that, okay, in these circumstances, even though it's after a year, right, it is still okay, actionable. Right, the court said. So the harm to the mother was due to, right, due to the conduct of the boy. But who are you going to sue? You are suing the first person who gave the information about the boy, right? So that is also, okay, a kind of a observation that we can make under the rule in Wilkinson and Downton. Yeah. So in summary, the revised tort addresses direct harm caused by false statement. It does not extend to scenario where harm is indirectly caused by a third party action following a false statement or omission by the defendant. Next segment was excusing, okay, defendant's conduct. So this section discusses the aspect of excusing the defendant's conduct under current Wilkinson tort and proposes changes for the revised Wilkinson tort. So current Wilkinson tort says it requires that the defendant's statement or conduct must lack justification or reasonable excuse. Right? There's no justification or there's no reasonable excuse. So in the Supreme Court case of Rhodes, it was determined that proving the absence of justification or reasonable excuse for defendant's action falls on claimant, not defendant. So this interpretation was unexpected to the author of the article. So the proposed change is that we need to reverse the approach, okay, in line with other torts that we have. So this change would align with revised Wilkinson tort with statutory tort under protection from harassment, where, right, the burden of proof for these defenses rests on defendant rather than proving, okay, burden of proof, okay, laid towards the claimant itself. Okay, the burden is on the claimant itself. It should. It's more like you must work on it like a presumption is made. Harm is done, presumption made, let the defendant justify on that basis. Consistency with trespassory torts. In other areas of tort law like assault and battery, D already bears the burden of proving defenses such as consent or lawful justification or necessity. So why not? Here, okay, under the burden, we will presume, all right, that the defendant has intentionally caused harm without justification. Let the defendant defend himself, right? So that is another change that the the author was proposing, yeah? So reformation of intent element. So a minute, give me a minute. Oh, it's already 8 o'clock. Let us take a break. Once we have done, because there are certain parts I can just skip very fast. Some of the parts only I'm going to focus because the rest is like more of a repetition already. Yeah. So we are going to go for a break. 8 o'clock, we will meet at 8:10. 10 minutes time, we will join back. Hi, okay, welcome back. Let's continue from where we stopped on the summary of the article itself that I have actually attached when I sent an email through Speed. So no new material shared today so far, but later I'll share the new material. So reforming the intent element. We are going into reforming the intent element. This section discusses the need for reforming the intent element of the Wilkinson tort, addressing the complexities and uncertainties currently associated with it. So, what could have been the issue? Firstly, ambiguity in current Wilkinson tort. So, the intent element in the current tort has been ambiguous and unclear. So, in other words, it is a slippery eel. Lord Hoffman highlighted the need for caution in defining what is meant by intent. Intent can be defined in various ways. Okay, so that is one of the reasons why we got to be very clear of what type of intent that we are talking about. So in defining the intent, okay, the current tort as affirmed by the Supreme Court in the case of Rhodes was that the D must intend either to cause C a recognized psychiatric injury, or to cause serious emotional distress that results in psychiatric injury. So that means the intention is not to give a false statement, but the intent is the result. We intended the other person going to suffer mental injury. Okay. So this interpretation is broader standard of intent than originally established in Wilkinson and Downton. So originally it was not really so, but in Rhodes, there was a broader, okay, definition and reduces the evidential burden on C, right? So the author said that the proposed revised tort simplifies this intent. It will be sufficient that D intended to cause emotional distress. That's good enough. Without the need for a recognized psychiatric injury. No need to go for that. So long that you intended an emotional distress, that is good enough. In consequence, if the person suffering from serious emotional distress or morbid depression or psychiatric injury, that doesn't matter. So long that you can prove emotional distress is there, it's actionable already. You can be successful. Okay. So the evidence shows that the intention was to improve C's well-being. Even if misguided, then defendant will not meet the requisite intent for the tort. Okay, if the intention is not, all right, established, if you are not, okay, intending for a emotional distress. Therefore, the intent must specifically be to do harm. Why the author is saying it? Example, sometimes we want to convey a message. It can be wrong. It can be a false alarm, but you're conveying with the intention to let the person calm down, relax. I'm going to tell you something that your husband in the hospital now. Yeah, there's an intention for not to cause harm, but to slow down the emotional part of the claimant. But it's a false alarm. On that occasion, okay, the intention is not satisfied. Okay, it must be an intention to, okay, I'm going to tell this, and this person is a wrong message, and this I want to see how the person is going to react, and the person going to suffer distress for a moment. I want to see that distress condition. Then in itself is good enough. So that means it's quite dangerous now. If this is accepted and adopted, and there was a move, because the court also looking into that move already, particularly in Rhodes. So in 2015. So which means if this move is accepted, then doing prank can be dangerous already. Doing prank itself can be dangerous. So in summary, the reform of the intent element in the revised Wilkinson tort aims to clarify and simplify the requirements regarding the intent, focusing solely on the intention to cause emotional distress, irrespective of resulting in a recognized psychiatric injury, right? The spectrum of intent, this part, a bit of dissection made, okay, on the spectrum of it. So this section outlines the complexity of the intents, okay, the current Wilkinson tort, detailing various types of interpretation, like for example, willful intent, okay, which can be seen, okay, in Janvier and Sweeney. Imputed intent, which was introduced in Wilkinson. Downton concept means defendant conduct was so likely to cause harm that an intention to cause the harm is legally assumed. This form of intent, sometimes termed objective recklessness or imputed intent by operation of law, was applied in Rhodes. Okay. Third one, imputed intent by operation of law, subjectively assessed. The variation implies that defendant knew the likely harmful outcome of the action, even if they did not actively intend it. Okay, right. Fourthly, okay, rejection of imputed intent by operation of law. Supreme Court in Rhodes declared this form of intent as having no role in the modern tort law, preferring the concept of imputed intention as a matter of fact. Okay, imputed intention as a matter of fact. The interpretation infers defendant's intention to cause severe emotional distress from the facts of the case, even if defendant may not have actively considered the likelihood of causing the harm. Intent based on recklessness, that's another, right? And I believe that you all know what is recklessness. And finally, foreseeability as intent, the lesser form of intent, we call foreseeability, okay, leads to alarm or distress, has been applied in Canadian law, but is not sufficient under English law. So in summary, the current tort has seen a wide range of interpretation of intent, from actual intent to something akin to reasonable foreseeability. However, the Supreme Court has preferred actual intent or inferred intent as a matter of fact, moving away from the broader interpretation. So that's what, okay, the author is actually suggesting, right, for English law. So finally, the suggestion on the intention is either actual intention or inferred intention. Actual intention or inferred, two specific forms that need to be analyzed. So the article emphasizes that these two forms of intent should be the only ones applicable under the revised tort, ensuring clarity and preventing an overly broad application of tort. This approach aims to provide realistic boundaries to address and to avoid floodgate concerns. Yeah. Right. Having said that, next part that the author suggested was about reformation of the causation. Reformation of the causation. So this section discussed proposed reforms to the consequent element, specifically focusing on causation and remoteness of damage under revised tort. Reforming causation. The current tort talks about but-for test and material contribution tests have been applied. The proposed change is, is to go for a strict but-for test, arguing a weaker material contribution coupled with lesser type of damage could open floodgate of claim. So this part, we got to narrow it down to only include but-for tests rather than material contribution tests, right? That it was a suggestion. Remoteness part, the two parts, to surpass reasonable possibility of the relevant damage and normal fortitude rule under the current tort. Proposed change, okay, the article argues for the removal of the reasonable foreseeability requirement of the revised tort. This is based on three reasons. The tort is closer to trespass than negligence, making foreseeability a less comfortable fit because it's akin to trespass rather than negligence. So when it's akin to trespass to the person, then we should not observe the idea of foreseeability. Aligning with trespassory torts like battery and assault, which do not require foreseeable damage, the strict but-for causation approach sufficiently addresses the floodgate concern, eliminating the need for a foreseeability requirement. Okay, so we do not need to go into the foreseeability part, but so long the causation is established, then the remoteness part, okay, is basically, right, something that has happened to the other person. That's good enough already. So that's a proposed change made by, right, the author. So in short, the idea is to make the tort more straightforward and consistent with other intentional torts, focusing on defendant's intent to cause serious emotional distress, irrespective of the foreseeability of the specific consequences, right? Then the author also, okay, introduced the new defense, justification or reasonable excuse. Are you having a justification or reasonable excuse for making such a statement? Okay, if you can, right, come up with this justification, then of course, okay, the tort is negated. You are not liable. Then you can also have another defense, which is a new defense called public interest consideration. I am making this statement because it is in the public interest. But if it is not in the public interest, right, then is an issue that we need to find out. So a new defense not in the public interest to litigate is proposed. The defense would apply to cases where it is not in the public interest to pursue legal action. So if it is not in the public interest to pursue legal action, then this particular tort will be, right, dropped, okay, at that point of time. It depends on the context, right? In what circumstances you have actually made that statement. So whether that will be in the public interest to take an action against the claimant or not, okay, even though you are suffering from such a harm. Then the third one, applicability in various scenarios. Examples where this defense might apply include workplace interaction, horseplay incidents, and domestic disputes. These are examples highlighted by the author. And also balancing with freedom of expression. So we need to balance it, right? There is a freedom of expression. We can express anything. It can be a false alarm. It can be right. It can be wrong. We have the right to express it, okay? Not something that, what do you call this? Harm is done, you are responsible where you don't have a proper defense. You can still argue because once you have leveraged the tort, then it may lead to a lot of litigation issues. A lot of new cases will come into the court law. Then the defendants also must be given an opportunity to defend, because if we don't develop these defenses, then we wouldn't know how far this tort can grow in a very what do you call the directed way, it's like, bow and arrow without any shield, you see. So that's what we are observing, okay. Finally, procedural safeguards. In addition to these defenses, existing procedural safeguards against abusive or vexatious litigation should continue to apply. This is to prevent potential misuse of the tort for genuine claims, such as suing for monetary gain without a valid grounds. So in summary, the proposed not in the public interest to litigate defense under the revised tort is intended to provide a balance between allowing redress for genuine harm and preventing litigation in situations where public interest or freedom of expression consideration make legal action inappropriate. So a bit of a enhancement been made by the author to make this tort more interesting to be litigated, okay, to discussed, to be deliberated, okay, in the modern world. Yeah. Finally, okay, the conclusion, of course, all these are reasons as to why these torts, okay, recommended, and these are the key recommendation, 5 key recommendation, right, on the distress part of it, on the amendment of the conduct, intent, and causation, defenses part of it, to fill in the legal gap, right, and preserving, enhancing a legacy, okay, in this particular thought. So every other things are under appendix already. I'm putting it in a what you call summary. Okay. Okay, having said that, we are done with a quick summary on this particular article. I believe that every one of you all would have read, okay, at least to the document that I've sent to you, the summary at least. Okay, what is the difference between, there's a question here, what is the difference between imputed intent and inferred intention? If you go back to that part, that is on page, again, let me see your question again. You said imputed and inferred. Imputed was here, correct? Yeah. Is it before that? No, right? Only this part, huh? Yeah, okay. So, imputed intent, introduced in Wilkinson and Downton. It was introduced in Wilkinson and Downton. This concept means defendant conduct was so likely to cause harm, that the intention to cause the harm is legally assumed. Right? Legally assumed. This form of intent sometimes termed objective recklessness. Right? So what is meant by objective recklessness? Subjectively, the defendant might not have intended the particular harm, but the conduct, the statement, we don't say conduct already, the statement made by him, if at all we analyze it objectively, right, it can be assumed that the other person will suffer harm. Okay, that is how we interpret imputed intent. Okay, Whereas the inferred intent, where is it? You said inferred intent. No, there was no inferred intent mentioned by the author. Here. Okay, here. So this is objectively assessed considering various external factors. These factors include C's age, the relationship history between C and D, the ease with which C can verify D's statement, D's demeanor when making the statement, any vulnerabilities, economic, physical, or social of C, D's knowledge of characteristics that might make them more susceptible to emotional distress, the number of people making the statement. So this is basically a bit more of a contextual element, we call contextual approach. Earlier was more of an objective approach, a reasonable man approach. A reasonable man will, okay, when you make this statement, a reasonable man, okay, in those circumstances will get affected because the intention can be seen, right, from the statement itself. Whereas inferred intention explained here basically relates to, right, the statement itself, and by looking into the characteristic, this sometimes we call this to be a multi-factors, right, from the facts in itself for the courts to decide. It's not subjective, but it can be subjective within the factual context. But it's an objective analysis also. It's still an objective analysis, not a subjective analysis. Are we clear? Can follow that part? Who was that? Sorry. Who's that? Jean, eh? Would you say that inferred intention is more subjective than imputed intention in the context of the rule in Wilkinson and Downton? In the context of it, because intention, definition of intention cannot be used similarly across the board. We can't use it across the board. In criminal law, the concept of intention in itself varied from one regime of cases to another regime of cases, especially like when we talk about Cunningham recklessness, Caldwell recklessness, then eventually changed by Crown against G, So those are different. But the terminology can be same, but the interpretation can change according to the substantive law that we are talking about. So here we are referring to tort law. So imputed intention is like Caldwell. Can we say imputed intention is like Caldwell? I would say that imputed intention is like Caldwell. Yes. Imputed intention more likely like Caldwell intention. Whereas inferred intention is not even a Cunningham intention, not even a Caldwell intention. I would say that is a bit more in between. I would say a bit more in between. Yes. Okay. Any other questions before we move on to the Q&A part of it? You can clarify anything else. Let's make sure that we digest, we understand. Even if you go through again for one more time, and two more times, or a few more times or so, it's important because somehow rather this is something that you cannot escape. You have to do compulsory. Yeah, so it's better to have a clear mindset of how we can actually understand the article in itself. Yeah. Okay, if it is no further question, let me share the new document, the Q&A document. Please confirm that you have received the document. It's just a mere guideline, right? Mere outline for you to have some idea on what kind of question that can be asked. And thank you, right? What kind of question can be asked and how we can explain it or explore from what I have actually given you. My guideline is very brief, but you can actually expand it, okay? right? And while I'm sharing it, if you have any question, anything to ask pertaining to whether you want to say or ask whether, okay, can I include this information that I have, you feel free to do so, okay? Right. And I will also highlight to you that this is not too subjective. There is some we call it as a scope that we can always fulfill. You don't have to be too worried about, it's very subjective, I need to write so many things. Is it so? No, not necessary. As long as you work within the article, that's very good already. But opinions are very important. Again, I'm stressing this. Opinions are very important. So there are two types of opinion the examiner may ask you. One is your opinion. So please please be careful with the wording of the question. What the examiner is trying to ask. Whether the examiner is asking your personal opinion or the examiner is asking you what would be the opinion of the author. So you must study the author's opinion. You must also analyze your own self, what kind of opinion you want to give. Other than that, it can be descriptive. That's all, right? So the document that I've shared is actually with 4 pages of questions, right? Let me check. This is the one, just double confirm again. Yes, I think so. Yeah, each segment. Okay, a few segments I've highlighted here. Number 1, under the introductory part of it, question 1, right? The questions can be worded, okay, as like, for example, what is the proposed course of action? Normally, the questions you can see, there are only 3 or 4 questions. Normally, they have 4 questions, A, B, C, D. So, but each question, normally they will come up with 2 parts. They won't give you 1 part or short question. No, they give you 2 parts. Okay, so one can be a descriptive part of it, and the other one could have been can be a prescriptive part or can be analytical part, or whatever other things that they expect you to give an input to the question itself. Yeah, from the article in itself, right? So let's analyze the first one. Question 1. What is the proposed course of action? Proposed course of action under the revised Wilkinson Tort. Proposed course of action. And how does it differ from the current one? Current one means not revised yet, the old one. Okay. So the outline of it is that revised tort introduces a modernized cause of action focused on serious emotional distress. This is one thing that you can highlight. All right. Caused by intentional statement. Moving away from the requirement of recognize a psychiatric injury. You can elaborate this if you want to, based on your understanding, but the keys are these. It seeks to address limitation identified in cases like Rhodes and OPO, where Supreme Court highlighted the tort's narrow application. Even if you want to explain what kind of narrow application, you can do so. Where Supreme Court highlight the tort's narrow, the reform is supported by academic and judicial calls for a tort that more effectively captures the harm caused by intentional infliction of emotional distress in the digital age, acknowledging the evolving nature of communication and its impact on individuals. You don't have, best is not to copy. Yeah? Try not, as you know, you shouldn't be copying, but how you can actually put it in the summary in your way. What the main changes that you can remember, what could have been the proposed cause of action, you see. Proposed cause of action means it must be an intentional thought, all right, that would have caused, intentional thought that would have caused serious emotional distress, rather than recognize psychiatric illness. And it should not involve negligence or other carelessness. So that means there must be an intentional infliction. And it should come through the communication due to the digital age. That means we are referring to statement instead of conduct. So you can elaborate it in that sense. You can elaborate it. Do not need to go beyond the article. You can work within the article, but in your own words. Okay. So whatever differences in the summary I've shown you, you can also input. The best is not to everyone to use your own. You can paraphrase the summary that I have in your own way. Then that will also be a good asset for you to use as an answer. Okay, right? And this is the first possible question that I'm actually putting forward, because I feel this is quite likely kind of the thing that I feel that it can be tested by the examiner, right? Second, under introductory notes again, why is there a need for reform? Some questions are overlapped. Some questions are overlapped, just to share with you. Why is there a need for reform? Why? This is basically highlighting the reasons why do we need to change the law? Why do we need to broaden this particular aspect? So, of course, number one is limited application. The current one has limited application and couldn't adapt to modern communication methods when people can suffer harm, right? And there is a commentary by the judiciary, for example, the case of Wainwright and Home Office, where it criticizes the tort for being far more often used than applied. Far more often used, but then applied. You can't apply because there's no tort, but often used in the society, reflecting its impracticality in addressing contemporary harms. The proposal aims to make the tort more relevant and accessible for victims of intentional emotional distress, especially in cases involving digital and social media. So you can see some overlap in terms of answering it, but the questions are worded differently. So you need to present your answer in such a manner. Okay. Third guideline I can give you is, what are the main criticisms of the current Wilkinson tort that necessitate reform? So more or less, you can see there's a similarity, but the way that the examiner asks can be different. What are the main criticisms? So the scope is narrow because it requiring recognized psychiatric injury, which overlooks the significant impact of serious emotional distress. Cases like Janvey and Sweeney, you can highlight, okay, right? Whatever cases used by the examiner, you can utilize it. Try not to use cases outside the context of the article. Try not to do that. That's not safe, all right? Not to do that. Unless your discussion opinion can be so from outside your opinion, from outside opinion, but not authorities. Right, Janvey and Sweeney demonstrate the challenges in applying the tort to modern harms. The reform aims to address this criticism by lowering the threshold for harm and focusing on intentional infliction of emotion. This one you can add if you want to, because we do not know what kind of question can ask, but basically we need to highlight on the criticism. Right. Number two, you can also highlight on other criticisms such as conduct part of it, okay, right? Because if we are adding conduct, then there is an overlap. There is an overlap between other intentional tort compared to this particular tort. There can be an overlap. So we have to, right, narrow down, okay, the scope. The criticism can also be made there. Criticism can also be made on the causation part if you want to tell. That also can, because causation part, judges are, in a way, using material contribution, right? But proposed is not to. So this is also one of the criticism, because we do not want to increase the floodgate of litigation by lowering the standard of causation. That is also, all right. Criticism can also be made, okay, on the intention part of it, right? To ensure that, that the intention part of it seems to be very vague, unclear. So you can also make a criticism on that. So a few. This is one guideline I'm giving you, so you can add whatever criticism you want to make on those points. Yeah, right. So that is on the criticism. Now coming to reformation. What changes are proposed for the threshold harm under revised Wilkinson tort? So what are the changes? So the proposal suggests lowering the threshold from recognized psychiatric injury to serious emotional distress, as supported in the case of Rhodes, to make the tort more accessible to individuals who suffer from significant emotional distress without a formal psychiatric diagnosis, right? This change reflects a shift towards acknowledging a broader spectrum of harm caused by intentional actions, aligning with medical understanding of emotional distress and its impact. That is the threshold of harm. That is the part. So the scope of threshold of harm in the balance of between the psychiatric injury and also serious emotional distress must be highlighted to the examiner. So you can elaborate this, right? Which will be the answer for this kind of question, right? Threshold of harm question we call. Okay. Question number 2 under threshold of harm can also be worded in this manner. How does the proposed threshold for harm under the revised tort compare with requirement under Karna? This is more of a making a comparison. Okay, a comparative analysis. Okay. So unlike the current Wilkinson tort, okay, which requires a recognized psychiatric injury, the revised Wilkinson tort expands actionable harm to include serious emotional distress. And this shift acknowledges criticisms such as those in Wainwright and Home Office of the tort's limited applicability and aims to provide a more inclusive legal remedy for victims of intentional infliction of emotional distress. So the key parts is, right, what we are trying to say, recognize psychiatric injury to be changed to serious emotional injury. In line with the case, you can submit an authority. You see, I'm submitting different authorities, Rhodes, Wainwright, the other cases like, I think Janvier and Sweeney, okay, right? All these cases, depending upon which context you are explaining from the article, right? So the thoughts, right? So and then you expand it from there. But we know already for the fact it is about recognized psychiatric injury change to serious emotional distress. Question 3, similar to that, under threshold of harm, what is the rationale behind lowering the harm threshold in the revised Wilkinson tort? So what is the rationale? What is the reason behind? You see, the point of discussion may be similar, but the kind of question can change. That's why I'm giving you 3 different types of question. Instead of asking, compare or make a comparison between the two, they may be asking, the examiners may be asking, what is the rationale? What is the reason behind this lowering the harm? So the answer can be different. This is to address the gap in legal protection. Right? So sometimes examiner can ask you combination, 2 and 3 combined. Compare and what is the rationale? Then you will need to combine the answer. Okay. So rationale is addressing the legal gap, the gap in the legal protection for victims of serious emotional distress, as highlighted in Rhodes, where Supreme Court recognized the need for the tort to evolve. Lowering the threshold reflects an understanding of the significant impact that emotional distress can have on an individual well-being, even in the absence of psychiatric diagnosis. And this is to provide an equitable and accessible legal remedy. That is the reason why we need to lower it down. We need to provide a more equitable and accessible remedy for the society who are suffering harm. Right? So that is, in each segment, I am highlighting 3 different types of questions. Sometimes there can be an overlap. So coming to like example, if that all the examiner is asking you on conduct element, what modification are proposed for the conduct element of the Wilkinson tort? Of course, right? What you got, the author was focusing on statements. Causing emotional distress. Expanding to include various forms of communication. This responds to the evolution of harassment and emotional distress tactics, especially online, as seen in cases like Khorasanjian and Bush. highlighting the need for the tort to adapt to new communication technologies. You can also say this conduct element, okay, disregard the act, rather it is involving the statement, and the statement can be in any form, for example, video, right? Voice statement, voice recorder, okay, pictures, whatever, right? So one way we are narrowing down to statement. On the other hand, we are expanding the scope of the statement. That's all. Following question on conduct element. How does the proposed change to the conduct element address current limitation of the Wilkinson and Downton, which I mentioned just now? By focusing on statement rather than broader conduct, the revised Wilkinson directly targets the way in which emotional distress is often inflicted today, such as through digital communication. And the change acknowledges the limitations as seen in cases like Wainwright, where the tort's applicability to modern forms of harassment was questioned, and aims to ensure the tort remains relevant in the digital age. All right, so we don't use conduct. We need to narrow it down. Conduct, it comes under different category, right? It should come under battery or trespass the person or assault or false imprisonment, but not Wilkinson and Downton. Wilkinson and Downton specifically addressed on statements, right? And broadened to include digital communications. Another type of question, the implication part. This is also another type of question. What implication do the proposed changes to the conduct element? So what can be seen in future? What kind of consequence you can see if we can implement this? That's called implications, right, for the future claims. So these changes, the changes could broaden the scope of actionable claims to include emotional distress caused through modern communication methods, reflecting societal changes and technological advancement. This aligns with the judicial observations such as those in Rhodes and OPO, that the law must evolve to address new forms of harm, ensuring the tort remain a viable remedy for victims of intentional emotional distress in digital era. So the way you answer can seem to be have some difference in terms of elements, okay, but the key part will be the same when we talk about conduct element itself. Okay, so conduct, no, it should be statements only, but how do we answer? Are we answering on rational? Are we answering on benefit? Are we answering on implication? Right, that's what the examiner's focus is going to be. Okay, so that is an example. Another example is under the defense. You may be tested under new defense. What new defense is proposed under the revised Wilkinson tort, and under what circumstances can it be invoked? So the article proposes not in the public interest to litigate defense for the revised Wilkinson tort. This defense recognizes, right, the need for legal balance between protecting individuals from intentional emotional distress and not litigating every instance of unpleasant communication. So provide for some, okay, shield for the defendant to protect himself, okay? Yes, communication can be unpleasant in many occasions and many circumstances, but not in all situations, right? Even though it is litigious in manner, but it may not be successful. Especially in the context of modern societal conditions and digital communication, it acknowledges that not all instances of hate-filled threatening, right, or demeaning statements should be actionable, stressing the court's role in distinguishing between actionable and non-actionable cases based on the facts and circumstances, right? That's what we are looking at, the defense part, okay, the new defense part. Now, another way of asking, how does the new defense align with Article 10? I see, freedom of expression part. So we know the defense is not in the public interest. So how, sorry, there's a defense called freedom of expression. Okay, how do we analyze this? So while the article does not directly discuss the alignment with Article 10 of the ECHR, the proposed not in the public interest to litigate defense implicitly supports the principle of freedom of expression. I mean, not in the public interest for you to litigate because we have a freedom of expression. Okay. By recognizing that not every instance of emotional distress caused by statement is worthy of legal action. The approach suggests a careful balancing act between the right of expression and protection against intentional infliction of emotional distress, akin to consideration under Article 10, which seeks to ensure that restrictions on freedom of speech are convincingly established as necessary. So there is a balancing interest here, right? There's a balancing interest here. So this brings the law more challenging. Okay, with other developments such as privacy law, other developments such as the false imprisonment, the recent development on that aspects, okay, you will discover, but even though we are not focusing on that due to the compulsory article, but it is interesting. The rule become more and more interesting in the modern world. It can become very popular in the modern world, this rule. Okay. Question 3. What challenges might arise in applying the non-actionable in the public interest defense? And how could courts address these challenges? Okay, this is another way that the examiner can ask what challenges might arise. Okay, what challenges might arise and how the courts could address this. So the main challenges lies in determining what constitute. This is going to be the challenge. The court had yet to develop this, if at all, this particular proposal been accepted. Usually the courts will take very serious concern on the development based on the article, right? We don't say no. Okay, but in the near future, we can see some changes, some proposals, some observation to be made because House of Lords, Supreme Court already observed this already, right? That the law should change or expand. So what challenges anyway? So the law yet to develop on what is meant by public interest and distinguishing between statements that should be considered actionable versus those are not. So courts will need to develop a nuanced criteria, variation, right? Different type of criteria, nuanced criteria for applying this defense. Considering the intent behind the statements, the context in which they were made, and their impact on the claimant. So it involves a complex assessment of facts and circumstances of each case requiring careful judicial discretion to ensure the defense is applied in a manner that balances the protection of individual with freedom of expression principles. So it is not that easy to recognize public interest, but of course, development yet to be seen based on precedents in the future, if at all, this proposal been accepted. And it will be slow, definitely. I mean, unless the number of cases increases, number of cases increase means, okay, good for the legal development. Unlike Rylance and Fletcher, you don't see the real development in Rylance and Fletcher, very slow, right? Even though interesting thought, but very slow. But this one can be expanding, was expanding area. Together with privacy laws, was expanding early. More and more cases may come to court, right? And the courts will be very busy in handling all this, and they are required to observe what kind of public interest element to be understood or to be highlighted. And that becomes part and parcel of legal development already under the ruling Wilkinson and Tort. So that is on the part of public interest defense. Finally, the examiner also can ask, okay, on conclusion, based on conclusion, what are the 5 principal recommendations for reforming the tort in itself, the rule in Wilkinson and Downton? The article outlines 5 key recommendations: prerequisite damage, adoption of serious emotional distress as the minimum threshold, directed statement, the tort should apply to statements only, moving away from conduct-based, the requisite intent, i.e. the actual or inferred intent as a matter of fact, right? Narrowing causation and remoteness as a strict but-for test should be used, and we need to remove foreseeability. A new defense, proposing a defense for incidents deemed not actionable in the public interest. Also a defense, also balancing it with what we call the Acknowledging it, the balance required under Article 10. See, these are the 5 key proposals. And I think by now, we should be able to encapsulate them. Okay. Emotional distress area. We talk about statement. Okay. The legal perspective part. The intention part. Causation and remoteness part. And finally, the defense part. Okay. Question 2. Another question, another way of asking, how would the reform of the Wilkinson tort enhance its utility in modern society? So we are trying to take one at a time and say how it is enhancing. The reform aims to make the tort more relevant to contemporary societal condition, acknowledging the impact of social media. Sorry, some error here. Okay, impact of social media and digital communication. By focusing on serious emotional distress, the reform broadens the scope of actionable harm, ensuring that the law adapts to modern forms of communication and harm. The emphasis, directed statements, and the clarification of intent criteria respond to the need for legal remedies that reflects the way individual experience distress in today's digital age. Right? What kind of intent? So we need to know people how they are going to behave after this. Right? And additionally, the proposed changes to causation and introduction of defense are intended to ensure that torts application is balanced and fair enough. So you can reflect it in that to the modern society. Another way of asking, what challenges might arise from the implementation of the recommended reforms to the Wilkinson tort, and how could they be mitigated? So challenges include the serious emotional distress, firstly, clearly ensuring the intent element is appropriately calibrated and balancing the new public interest. Defense with the need to protect individuals from harm. How do you balance that? Mitigating these challenges may involve judicial guidance, of course, regarding intent and the scope of new defense. Further, courts will need to navigate. This one is basically the court's decision, but how the courts navigate is going to look into the public interest part of it and the intent part of it, okay? How to balance that. That's what the challenges that the courts are going to have, right? Further, the courts will need to navigate the balance between the protecting individual emotion. This one I mentioned already, right? Non-actionable in the public interest. Continuous monitoring of the case law development and possibly legislative guidance could help in refining the torts application to ensure it meets its objective while avoiding unintended consequences such as overwhelming number of claims. So chilling effect, right, on free speech. So what we see is like, sometimes like psychiatric injury kind of cases, right? When the courts, for the very first time, okay, allow, right, the claim for psychiatric injury in Dully and White, slowly there is an expansion seen. Suddenly, the litigation increases. When come to certain stage, the court had to put a full stop. So they got to narrow it down. Control mechanism comes in. So here, we have yet to see that there is a new opening. But once new opening come, then you will discover, then only we will discover what is the implication, how much of cases coming in. Then the law will need to streamline it accordingly, right? Before what we call maturing the law, okay, maturing the law in the modern society, basically. So all these questions that can be seen, okay, in the context of what examiner is observing, right? That means what we are saying, proposed cause of action, the proposal by the examiner, the need for this kind of reform, or the criticism part of it, right? Proposal part of it, or comparative things that we need to do, or we want to talk about rationale, okay, proposal, comparison, limitation, rationale, implication. These are the key things you can see from the cases, from the sample questions that I've actually highlighted here, right? Okay, how it works, the workability of the defenses example, okay, how it must arise, what challenges that we are facing. So the question will be focus on this kind of key aspect. But the only thing that which I cannot suggest to you now, how the examiner going to tune it, even though the content can be similar, but the examiner may tune some questions or one question in a subjective manner. And that one question can be the perspective of how you present it in the mind of the author. In the mind of the author, what do you think? That kind of a subjective question, if it is there, then you got to be a bit more careful what you are trying to say, right? Because it needs to be understood from the perspective of the author. Not a statement made by the author, but the perspective of the author. Statement made by the author is here. Perspective of the author is what she is determined to propose. That one you need to reading down the notes, the article in itself. Okay, every part of it. That's an exercise that you need to do. All right. The other one is, okay, which is not going to be difficult, is when the examiner asking, what is your opinion? Not author's opinion, your opinion. So that will be a second part. Maybe one part they say, what is a proposed, let's say, for example, here, right? What changes are proposed for the threshold harm? So what the author said, changing psychiatric illness to serious emotional distress, good enough already. Then what is your opinion about this? Will this allow this particular thought become more lively? What is your opinion on this option in the perspective of the current development of the law of thoughts or whatever way that they can ask you? So then you need to give your opinion, whether this is a good idea, this is a better perspective from the rule in Wilkinson and Dalton, or if it is not, why do you think so? Right? So that part is going to be something challenging. If at all they ask maybe one question, yes, you have to answer. If it is not, then that's good enough. You are, answering. I don't say that it will be a sure question, but it is highly likely there can be a question. I don't say it's a sure question on opinion-based question, right? So having said that, we are actually done with the article. So feel free to digest your mind. And if you have any further question based on the sample questions I've given to you, you can chat it in the chat column, right? I will be of assistance to you. And we are going to go for a break now. Okay, final break for the day. That is 9:03. We will take about 7 minutes. 9:10. We will meet up for the final session. That is for public bodies and other general questions on tort law before we end the entire workshop series for the day. Okay. Hi, welcome back. So we are resuming now. Okay, before we get into further parts, the part A, the public bodies. Not part A, sorry. Public bodies revision questions. I will like to see whether anything that needs to be done. I've actually attached it already, so you can actually you can download. And can someone of you confirm that you can download the public bodies revision material? Right, please confirm that you can download. Yeah, okay, thank you. Thanks, Samuel. Thanks, Kate. Thank you. Right. There is a question from Samuel. Answers to part A questions could be pretty to the point. Yes, we should not linger on the elaboration on each point stated in an answer. Is this a correct understanding? Yes and no. Yes and no, right? Question should be pretty on the point. We should not linger on the elaboration on each point stated in the answer. Elaboration may be needed only towards if you are forwarding two perspectives, two parts. Okay, number one, or two ways. One is if you are trying to reinstate the point based on the authority, then a bit of elaboration required. Okay, but not too detailed, not necessary. Just right on point elaboration. Okay, perhaps on the key reasons. Okay, and the other part of elaboration that you need to do, okay, if at all there is a what we call opinion-based question, yeah, you need to elaborate. You can illustrate with something that you want to say. Then elaboration may be required. Other than that, no. Other than that, you need to go straight to the point from the article in itself. From the article in itself. So what I've given to you is a straight to the point, but very brief. So slight expansion required, but not too much. So which means if at all, going back to that article again, just to share with you, going back to that article again, going back to like point number one here, question number one itself, there's just one question here. So what is the proposed cause of action under the revised Wilkinson tort? So what is the proposed cause of action under the revised Wilkinson tort? So the proposed cause of action, okay, under the revised tort is to change it to serious emotional distress in state of psychiatric harm. All right. And okay, and the intentional part must be stated clearly. The intention part must be stated clearly. All right. So that is the proposed part of it. Then, of course, you can actually make a bit of, right, an elaboration on that. Make a bit of elaboration on that. What is meant by serious emotional distress compared to recognize a psychiatric injury, right? Not too detailed. Okay, so let's say we have like here, 1, 2, 3, 4, 5, 6, 7, 8 lines. So for normally for in your typing page, for one question, okay, normally it is your length of typing with no collaboration of 11 font 11 12 should be 1/3 of a page to half a page. 1/3 of a page, I think should be okay. All right, 1/3 of it. So if you look into the whole thing here, right, it's like one page here, right, with font 11, you could see to answer one question, I think you can explain it in this length. That's good enough already. Okay. One important advice I would give, do not take too much of external material inside. That shouldn't be done. When I say pretty on point means it should be within the article. Within the article. So I hope you got the point, Samuel. Unless you may want to try it out, okay, and then submit it to me. Maybe one question. Let me go into detail and make a comment to it. Then from there you will understand what I'm trying to say for some of you all, right? Because sometimes practice makes perfect. All right. Even though I'm not in the practice in ATC, okay, I'm part-time only, but I will still try to spare some time. Okay. Of course, with the current state of timetable that we are having here in Malaysia, right? Noting that there's a public holidays coming in, okay, due to some celebration in they call Hari Raya here for 1 week. I think this week onwards until the mid next week. But still, I will try to find some time to, mark, okay, even though I'm on break. That will help a lot, maybe, on the perspective of what you are looking at and what I'm seeing, yeah, right? So I do see another question, I believe, from Wing. You can spend more focus time on this area because the public bodies I can run through fast. It's not a popular area and most students may not want to attend. But anyway, I have a guideline for you already. Yes, Vic, your question? You're typing, I guess. Could you provide some notes for trespass to the person? Some notes for trespass to the person. I didn't give you, I didn't give you. Okay, let me check. Can I share it here itself, easier? So that, no, I don't overlook. Some notes on trespass to the person. Let me see what other notes I have. I don't know whether I shared with you. If not, let me share it. Trespass to the person. Notes. Okay, just a minute. Right. What I can share is the summary from the subject guide. Normally, I use it as a lecture guide. I want to practice one question in the coming exam. Sure. No worries. Okay, let me get that. Love dot. Trespass to the person, notes. Okay. There can be an overlap of the material because there are many materials, okay, for different segments, but let me share a few that I have. Presentation, the lecture notes. I have one here. Then one more is a bit of a supplementary. I don't know how much of cases I've highlighted, but okay, 3, and I give you one more. There could be some overlap between one note to another. There's one more note, it's on trespass to person and land. So let me send all these 4. So there are 4. Just double check, but if there is a similarity, maybe 1 or 2 documents similar means not necessary for you to read both. Okay, so one is my personal summarized notes. One more is from the lecture. Okay, that is PowerPoint lecture. The third one is supplementary additional materials. Fourth one is subject guide extraction. Yeah, trespass to person and land. Right. These are the 4. Got it? Okay, that is to Soft Wings request. Anything else? Thanks, Kwan. Right. Okay. Anything else you need? While you're figuring out what you need, okay, let me also share, okay, screen on what we are going to do now. That is on the public bodies, yeah? Okay, just open the page before I share. Okay, coming to public bodies. Experiencing from the past years, okay, usually public bodies will be focused on 4 types of question. Okay, public bodies will be focused on 4 types of question. But the materials are the same. The contents will be, I mean, the law reports or cases all almost the same. Okay, sometimes you may need to focus on one particular area. Sometimes you need to be general to all aspects of public bodies. That's what I'm trying to say. But the focus of the questions, there are 4. One is the questions will be focused on police. All right, primarily on police only. Second type of question, which we can say general public body question. General public body question. Third question will be focused on the concept of what we call omission, because whenever it comes to omission, we are normally focusing on public bodies. Okay. And fourthly, we'll be focusing on HRA, Human Rights Act. These are the 4 different ways that the examiners can ask on public bodies. Out of these 4, this is the most popular one for police. What do you call this? Liability. Okay. Now, so the guideline that I've actually shared, right, with you will be what do you call this? Covering all 4 areas. Covering all 4 areas, but the part that I have actually inserted, right, additionally, okay, outside what I've actually sent to speed, okay, would be more of a concept of how do we analyze and evaluate. Okay, the content part is already there with you. You would have read it, but this is just an evaluation analysis. So when you have the idea of evaluation and analysis, then it's easier for you to answer the question. In every other perspective also, other topic also, you may utilize them. So that is what we're going to look at. Meanwhile, I'm also looking into your questions and requests. Let's see what, oh, right, wait, no problem. Thank you. Okay, and let's start off with 2021. So why 2021? You do not see any questions in 2022 and 2023 purely on public bodies. There could be some element of public bodies like police or what, but not a full question. So last they have tested the students were in 2021 on public bodies. Yeah. Okay. So this was a question in 2021. Question 2, and the focus of the question was on the police. The duty of the police for the preservation of peace is owed to members of the public at large. Okay, right? Preservation of peace to the public at large and does not involve the kind of close or special relationship of care. Lord Tolson against Michael against Chief Constable of South Wales Police. In, I think, Michael's case was 2015, if I'm not mistaken. Right, 2015. So the question that has been posted to you, it will be, what is the duty of care and negligence owed by the police and what are the reasons for it, both in legal principle and policy? So when we say legal principle, is easy, right? Foreseeability of harm, proximity of relationship. Comes to policy, yes, whether it's fair, just, and reasonable to impose a duty of care, right? Okay, so of course, everyone would have had this benefit of having the three-pronged test or other singular composite test as highlighted by Lord Bridge in Caparo Industries and Dickman. Of course, Caparo Industries and Dickman is not a case pertaining to police powers, but it is a case where the law been recognized in terms of the tests, proper tests to be used. But before Lord Bridge came up with the test, okay, it was commonly, okay, understood that when you want to establish a duty of care, there are two parts. Okay, two stage we call, and those two stages already been highlighted in 1932, or rather developed by Lord Atkin in the case of Donoghue and Stevenson. That is foreseeability of harm and proximity of relationship. So since 1932, whenever there were actions against police, the courts had this benefit of using the foreseeability and proximity. Foreseeability and proximity. These are the two things the courts would use. Even if they want to dismiss duty of care on the part of the defendant, okay, the courts will either see whether it's foreseeable or is there a proximity. The limitation were there. All right. This is a bit of a timeline. And in 1972, in 1970 or 72, Lord, what we call Lord Wilberforce, okay, Lord Wilberforce came up with two-part tests, okay, twofold tests. So his lordship came up with foreseeability and proximity. Then there's a prima facie duty of care, and whether there is any form of reasons to dismiss such a duty or not. Okay, that is also the second part of it. Okay, whether the duty can be negated, right? That is also another thing. So what happens? Okay, I need to run fast because there's another topic also I need to run through quickly, right? What happened? When Lord Wilberforce came up with that particular test, what happened? Judges later, after Lord Wilberforce's test, okay, right, refused to follow that test because it doesn't serve the proper purpose under judicial decisions. So that is one of the reasons why the court still went back to Donoghue and Stevenson. Even in the case of Hill against Chief Constable of West Yorkshire Police, the courts negated the liability or rather duty on the part of the police when no, it's about Yorkshire Reapers case, right, murder case of the one woman, right, and eventually the mother sued the police for that. So the court used the word proximity, argued based on the proximity element, no proximity. However, after 1990, because Hill was decided in 1988, but after 1990, then the courts, after referring to Caparo, they had the benefit of looking into the third limb, that is whether it's fair, just, and reasonable. So that's where they decide, okay, whether there can be a duty of care. So this particular topic, all right, will be focusing on the duty of care element and whether policy needs to be, right, observed, okay, by the courts. And even if they observe the policy, what is the justification they make in order to decide whether there can be a duty of care or not. So all the guidelines being given to you on this area, right? I've given to you the guidelines on this area. Hill, right? From Hill, cases like Van Cole, Chief Constable of Hertfordshire, Osman and UK, Smith against Chief Constable of Sussex, okay, for common law negligence concern, a claim for common law negligence again. So all these are material. Robinson is the most recent case, okay, on this area that has actually remarkably, okay, made a very important statement, the judges, about the possibility of police can be liable for positive action, right? Even though there is no specific duty involved, but for positive action, generally, you can use Donoghue or other Caparo easily, okay? But for omission, then you've got to go back to defensive practice, okay? Defensive practice. So that is the importance of Robinson. And I have actually highlighted some of the points of evaluation and analysis should you plan to do this topic. Now, my concern also, how many of you all are planning this topic? Because there are two topics here. For me to balance it, to share some information, there are two topics. One is negligent misstatement topic. Okay, one is negligent misstatement. The other one is also duty of care, specific duty, and the other one is public bodies. Right. So, any one of you all are focusing on any one of the topics or both? Can I know? Maybe wave of hand. negligent misstatement question, wave of hand. Let me see the majority. Where in Malaysia, nobody will want to do public bodies. Okay. Negligent misstatement, possibly, yes. Right. So let me, with the flow of time I have, I can just balance the material that I show you. Oh, I haven't shared negligent misstatement yet. Right. This is on the part of pure economic loss and negligent misstatement. Modified notes. I've inserted some further elements here. Okay. If that's the case, let me share first on the public bodies. This is the first part. Okay, on the analysis and evaluation, notably points like specific responsibilities and assumption of responsibility on the part of police, particularly on two cases here. General public function and core principle as highlighted in Hill against Chief Constable of West Yorkshire. Right, this is also another point of discussion in terms of analysis that you can make. Evolution of legal principle, how the courts are evolving their legal principle, whether they are capable or they manage to do that, okay? And was it consistent, or it is basically a blanket principle, blanket immunity, no duty as established in here. Okay, and then the recent development that you may need to, okay, put forward for Robinson against Chief Constable of West Yorkshire Police. Should you have any question, feel free to ask these authorities. Expanding the scope of liability, yes. The role of positive acts, as I mentioned just now, this is where the court, okay, move forward to expand the liability of the police if there is a positive act. Robinson is the authority. What about the intersection with human rights? That is also another concern. Okay. Policy consideration, a bit of a stone information about policy consideration must be made, okay, in terms of police power. So these are the authorities and these are the flow of analysis that you can work on, right, on the part where we talk about police powers, police duty, in other words. Next type of question, let me see whether this is, yeah, this is a general question on omission. So when there is a general questions on omission, the responsibility of police or the duty of care on the part of the police is can be one part of the answer, because omission is a key segment of it. So in this context, you can actually use some other authorities, okay, from your public bodies, such as Smith against Littlewood organization, right? Even though this is not focused on what we call public bodies, but it's a general negligence case where we talk about the omission liability by the Littlewood's organization, limited. Limited is not a public body per se, right? And also you can, okay, cross refer with public bodies such as Michael and Mitchell, right? Police case. And then local authorities such as Phelps against Hillingdon, okay, London Borough Council, right? And also Goringe against Calderdale, Metropolitan Borough Council, okay? All this normally, okay, relates to public bodies only, even though it's not necessarily for you to highlight public bodies per se, but because it's general omission question, but mostly it's like that. Like, for example, Home Office against Dorset, yeah. Again, this is about omission. Barrett, Ministry of Defense, right? And also the case of Tomlinson. Okay. So having said that, what we will do is we will get into the discussion based on the authorities that you have. And there are some key principled discussion I have actually put forward here. And based on those authorities, one is general principle against liability for omission, where we are referring to Smith, and we are also looking at the supportive case such as Mitchell and Michael. And then exception to and policy consideration, how the courts are looking at exceptions where there cannot be assumption of responsibility unless there is a specific responsibility, right, exists. When there is a specific responsibility exists, then this can be an exception already. Then there can be a duty of care, right? And situations like, duty of care in special relationships, such as Home Office and Dorset Yard will be very relevant, okay, for you to establish a duty for omission, right? Because there's a specific duty involved to ensure that postal boys are not, right, going out of the island, you know. So if there exists a specific duty to a particular group of people, then of course, chances are public bodies can be responsible, okay? Public services and omission principle, comparing it with the case of Robinson, how the courts are quite clear about positive acts and omissions. Okay, the observation of the courts. Liability of the fire brigade, yeah, not only police, we can also look into fire brigades, local authorities, and so forth. So it's a bit more for flair approach, okay, to answer the question. Some of the reasons why the courts are reluctant. These are general reasons that I've encapsulated for you to read. Okay, and this continuation of it and the conclusion part. So this is another type of question that you can have. Police immunity. This is police. Both the questions are on police. I'm browsing through fast, as I have already done one question above there. Public bodies, this is generally a question not about omission per se, but the key phrase or key parties that we are referring to will be the public bodies. Yeah. So this is another. So the answer will, the content will be similar, but the framing of the presentation can change, okay, depending upon what the examiner is focusing on in the question itself. So here, all the authorities are there, and I have brought all this authority in, what we call this, into what we call points of discussion. Yeah, points of discussion. So this part is, I would say, similar to the question where we are talking about omission liability also. You can use that as your guideline, because this is also a general question. This is also a general question. Next one, it will be human rights. This is another type of question. Human rights principles have played an important role. So this is slightly different from earlier types of questions. So when it comes to human rights, we need to focus on some of the articles, particularly 2 and 3, right? And then cases that you can see can be different from earlier cases also, like Commissioner of Police of Metro Police against DSG, relating to human rights, Ministry of Defense. All these are cases that eventually brought to European court, ex Bedfordshire, eventually brought to European courts, like reported as Z against UK, you know, this is an example, and also TP and KM and UK, right? And on this part, I did work on an approach, analysis and evaluation, influence of ECHR, what is the general obligation of ECHR, modification and expansion of tort law based on ECHR decision, okay. Case law illustration, that's what required to be done. Some of the case law to be highlighted, so I'm putting it in summary over here. Challenges and criticism that we can see from the decisions either in the Apex Court in UK and also European courts. Expansion of duty of care through human rights, how human rights, okay, in some ways manage to, right, reject the contention or other decisions made by the UK courts and provided the protection, right, to the individuals, right, when the cases brought to Strasbourg court. And what kind of caution or limitation the courts have, okay, in the United Kingdom, right, in terms of dealing with this kind of issues, human rights issues. What can be the future direction, suggestion, what would be the future direction and challenges that we can see, right, pertaining to human rights claims, okay, by the citizens in UK. So this can be said to be slightly diverted from the general, okay, question, but usually relates to public bodies. The challenges are related to public bodies. Okay, so these are some of the examples that you can observe, should you, okay, have inclination to do public body question. Now, having said that, let's get into the last part, that is looking at pure economic loss and negligent misstatement. This is also considered to be kind of a popular topic. I don't say no, right? It is considered kind of popular topic, but because of the comparison of the preparation by the students, okay, between psychiatric illness and negligent misstatement, many students prefer to do psychiatric illness because quite related to personal injury and a bit more uh, what we call structured, even though there's some issues pertaining to the modern development, but it's not as complicated or as what we call uncertain as negligent misstatement. And sometimes depends whether the examiners are testing students on a pure economic loss or negligent misstatement, because pure economic loss is a broader version of specific duty, right? It involves defective premises, it involves careless workman cases, it involves contractual interest cases, and it involves freestanding economic loss, that is negligent misstatement cases, right? So examiner can ask you generally on this, or the examiner normally can ask you a focus part, okay, where we talk about negligent misstatement. So looking into the flow of past year, right, from 2023, right, downwards, right, the final question that was tested, okay, last year was on an essay question. Describe and analyze, citing relevant case laws, the approach of the English courts to the tort of negligence where economic loss has been caused by the provision of information. So economic loss has been caused by the provision of information. Now, as far as what we call negligent misstatement is concerned, I trying to recall whether I did this topic with you or not, but with you, with Hong Kong or not. But one thing that you need to remember that when we talk about negligent misstatement, the very first authority that recognize that there can be a possibility of liability under negligently made statement, okay, would be the case of Hadley-Burn and Heller. Okay, these are the key things that I wanted to share with you. Hadley-Burn and Heller. So Hadley-Burn and Heller came up with a test called assumption of responsibility. Whereas in any other situation, the test to impose a duty of care was Donohue's test, neighbor principle, the foreseeability of harm and proximity of relationship, right? But when it comes to negligently made statement, House of Lords will, for the very first time, okay, establish a new, okay, a test called, right, special relationship, okay, i.e. the assumption of responsibility and reliance. So this is what we call the Hadley-Burn principle, okay, Hadley-Burn principle. So it has been divided, okay, for normal negligence situation like acts or omission, conduct that we use foreseeability, proximity. But when it comes to losses suffered as a result of statement made, report submitted, all right, faulty, then it should be a negligent misstatement. So when these tests developed parallelly, right, it came to a halt or a stop check, we call, at the time when Caparo was decided. Because when Caparo was decided, right, Lord Bridge came up with whether fair, just, and reasonable to impose a duty of care. So the question now, when Caparo was relating to auditor's report, it is not about action or omission like how Donoghue was decided. It's not a normal driver, you know, that kind of situation, but this is about report. But Caparo came up with a test. Duty, I mean, the foreseeability, proximity, and whether fair, just, and reasonable impose a duty of care. So the question here is now, at post-Caparo, when if there is a case where we talk about statement, are we going to use assumption of responsibility test or are we going to use Caparo's test? So some confusion okay, seem to have mounted in the court of law. However, judges are interchangeably using, okay, either test, either assumption of responsibility. So there's no coherency in the application. No coherency in the application. All right. To the extent that assumption of responsibility not only now used under the normal negligent principle cases, like for example, accident, normal like action and omission cases, also includes statements. Also includes, assumption of responsibility not only used under the statements, but also used under normal negligence situation. A good example I can highlight to you is Woodland against Swimming Teachers Association. That's a good example. You know, the teacher training the kid was injured. It's not a statement. It's about training a kid, taking care of a kid. But the court used assumption of responsibility test. So a bit of a confusion there. Then comes to three-part test of Caparo, that is foreseeability, proximity, and whether fair, just, and reasonable. Judges are using it, okay, not only under a normal negligence scenario, but also using it for statement. Caparo itself is a good example, right? And there were other development of cases where judges are using both the tests interchangeably. So it merely became a slogan. There is no clear guideline given by the courts already, right? So today we have two tests to be used. Either you want to use Donaghy style test or you want to use assumption of responsibility test. There is no harm. There's nothing is wrong. Okay, so it depends on whether in the future, right, there can be some form of halt to be made to reinstate the law in a proper manner. That is one aspect of it. The second aspect of it, of the negligent misstatement cases, will be that the judges not only using assumption of responsibility test, okay, or in negligent misstatement, judges are also using it for negligently given advice. Assumption of responsibility is expanded to include advice. Assumption of responsibility also expanded to include negligently made services. So not only statement, now even when people giving advice, then there will be, you can use assumption of responsibility. When you are providing services, like lawyers providing services, the courts can still use assumption of responsibility. So these are the two front of development you can see. One creates uncertainty already. The other one creates another expansion. When originally this supposed to be a very restrictive mode of approach by the courts. Not easily the courts are allowing liability to be made. So when negligent misstatement expanded so well, other area of pure economic loss did not expand to such an extent. The pure economic loss, like defective premises, when we talk about careless workman cases, contractual, did not expand to the extent of how Hadley-Burn principle expanded. So that is why this area is very popular. Okay. So having said that, if you look into the authorities like Esso Petroleum Marden, Caparo Industries, okay, Spring Guardian Assurance, okay, also another notable case for job reference, right? Williams and Natural Life, okay, also where it expanded to services, right? And yeah, the common error, a bit of guideline given by the examiners. That's one. Secondly, which I've given to you, will be 2023 Zone A, right? This is a question focused on defective buildings. This is a question focused on defective building. All right. So it's a bit more of a focused question. This is where this can be a bit more dangerous if you are not focusing on this area, because not always they ask you about negligent misstatement. They can ask you this area. So it's quite uncertain how the examiners are testing the student. And this is totally, I would say, almost different in terms of authorities that we are using. For example, ANS, we are using Simaan and Pilkington, DNF Estate Church. Okay, so the line of cases are varied compared to Hadley-Burn's cases, Murphy and Brentwood, and moving forward with other cases, right? And then this will be a student extract. And then I have an answer guide here for this question, right? To be highlighted, evolution of the case laws from ends to DNF estate, right? And then policy consideration, okay, and complex structure theory. That is for defective premises argument here, okay? Now, here on in 2022, the common law prejudice against recovery for economic loss should be seen as a general reluctance. So this is a not defective premises, not negligent misstatement. It's a general pure economic question, law question. And if it's a general pure economic loss question, again, the flow of the pattern of the answer will be different. It's not the same. Okay. And you can see the line of cases are different also, generally speaking, starting from Kettle against Stockton Wharton Works, right? Which you can see this line of case been moved into the application, right? Further application by the case of Valor against Food and Mouth Disease Research Institute about the farmers, auctioneers and farmers case, right? Applying what you call Kettle's case, right? On the pure economic loss. And you have another popular case called Spartan Steel, right? And the more recent decision, Konakan Group against Network Rail Infrastructure. All these are cases relating to pure economy. Now, a bit of Murphy and Brandwood cases can be inserted in terms of the discussion, right? Because a general pure economy, you can cover anything. You can also cover negligent misstatement. So negligent misstatement, defective premise, right? Careless workman, all can be part of your answer. It's a very general question. Yeah. All right. And moving forward, before these cases, I've also given you a guideline here, all right, in brief, right, how to work out on the authorities that we have. And if you look at examination paper 2022, these, like before 2022, more often than not, examiner preferred to ask quite, okay, popularly the negligent misstatement. But recent years, okay, like 2022 onwards, there's a bit of a variation in terms of what they're asking. That is why students need to be aware whether are we ready to answer this particular topic. But if you are prepared for negligent misstatement, good. In the event it appears, you can answer, right? Chances are higher because this is more popular. So this is on negligent misstatement, assumption of responsibility by Lord Hoffman case, essay question also. It's not a problem question, it's an essay question. Authorities are given, right, for discussion. And this is also in 2022 October, assumption of responsibility question, all right, based on the statement made by Tofaris. Earlier in 2022 October, right, we are also having, right, negligent misstatement also again, right, on that. So 2022 mostly on negligent misstatement question. When you go back to 2021, also negligent misstatement question, also, but they were problem question, not essay. They were guidelines is here, right? Problem question. Together with 2021 October, also a problem-based question. And normally problem-based question can cover 2 or 3 aspects, either statement with advice or statement with services or advice with services or all 3. They will mix and match to see whether students are able to see the based on the new development that we have in this area. So that is negligent misstatement. 2021 also about negligent misstatement question. All right. Problem question. So there was some line of problem question in earlier years, 2021, and going backwards to 2021 also, this is 2021, also the same. All these are problem-based questions relating to Hadley-Burn and Heller. Okay, so in terms of what we can see here, right, the flow of past years, before 2022, 2021, you can see examiners tested for a couple of years various types of problem question focusing on negligent misstatement. Right, and then come forward to 2022 onwards, there is a slight switch to essay question, but different areas of pure economic loss. All right. Of course, 2023, I think the courts are concentrating on provision of information. Okay, it's not negligently made statement, but provision of information. So provision of information can come in different form, in a statement manner, in an advice manner, or in a service manner. Okay, so we need to highlight it accordingly. That is more recent approach. So what we can expect for this year, on the part where we talk about pure economic loss, uh, either the examiners are going to generally go back to any one of the areas of pure economic loss, right? Or specific area, or they can come back to the old tradition of giving a problem-based question. So there is nothing uh, uh, what we call the cast in stone, what kind of question that they can ask you. Okay, it can be anything. So these are the two other areas that we're supposed to quickly run through. Okay, one is public body and negligent misstatement. So the focus of these 3 days revision, right, entirely on the upcoming or oncoming popular area where the examiners will always want to test nowadays because of the new area, which I need to run through the notes with you, will be the privacy and misuse of private information. And also, I need to stress a bit on the trespass to the person for your understanding, because if you don't understand, then you might find it difficult for you to do the article itself. So I have to go into trespass to the person. And today I have concentrated on the article in itself with the necessary guideline that you should have, and then to run through the two other common area that you would have done it during your tutorial session, but as a past year question, can be said to be less popular, okay, for the students. If we have more time, definitely I go through the detail, but I need to decide on the priorities, okay, what the best for you for this year to be prepared, okay? But if you want to do any questions you want to send to me, feel free to do so, right? I will be of assistance to you. Okay, that is to have a brief workshop on the last two parts and also earlier parts for this particular semester, right? We have another 3 more minutes. Now I'm opening it up for you. Should you have any other things that you would like to share upon, discuss, or request, feel free to do so. I'm still around for today, for a moment before we end the session, yeah? So is anyone typing any question just in case? Okay, right. So let's get the ball rolling. Is it difficult to get good marks? To pass tort, I would say it's not difficult. Tort, unlike property or other technical subjects like, even evidence, okay, is difficult to pass. But tort, you may find it not difficult to pass. But to score is difficult. To score is difficult. So as far as I'm concerned, out of 100 students, let's say, for example, to score an A, you may see 2 students. That's the range. But to score B plus and B, there are many students scoring B and B plus. Passing rate is high for top. Last year, passing rate was around 82, I think 80 to 85%. I'm looking into the percentage in Malaysia. Huh? Even the nation worldwide percentage was like kind of 80 something or so. So passing rate is not a difficult thing, but to score will be a bit difficult. Okay, that's to answer your question, Wing Chiu. So to get good marks, as I said, more analysis, more evaluation required. Law is there, not a difficult thing to highlight the law. Any other questions? No? If no, okay, it's already 10 o'clock. With that, I wish you all the best. All right. Hope you get the good results or best of yours. Right. And I hope I can see your results, okay, from Malaysian end, okay, once everyone that hopefully, okay, you have done well in your examination. That's the most important thing. So with that, okay, you take care. Have a nice day or nice weeks ahead. Okay. Right. Bye-bye. Hope to see you all soon. Bye-bye. Thank you very much. Thank you so much. Bye. Bye. Take care.